All right. Hello, everybody. It is October 9, 2025, and I'm here to talk with you about attorney's fees and getting paid. Now, I know you were expecting Shelley Kester. This is not Shelley Kester. Shelley unfortunately had a family emergency, and I'm so grateful to both her and Vivian, who is actually one of her associate attorneys. Vivian got recruited last night to join us instead, and I'm so pleased. And actually, Vivian has quite a bit of trial experience and courtroom experience. So, having talked to Vivian, I feel very comfortable that we are going to have a great session today. Vivian is, like I said, with Shelley Kester's firm at Wilson Kester in Traverse City, but Vivian is physically located in Oakland County. So she practices in the Tri-County area, plus like Washtenaw and Livingston. And again, Vivian, thank you so much for joining us today. We very much appreciate you being here.
Thank you, Lisa. Thank you for having me. I also do go up north a great deal as well, obviously.
Well, that's always a bonus.
Yeah.
So last time when I was here with Shelley, this was back in June, we had a whole webinar and it was about getting paid. And we really spent most of it talking about how to increase the likelihood of having our own clients pay us, by how we do things. And so if you weren't there for that webinar, you haven't seen the recording, we can make sure we get it to you. But before we move on to the actual, the part we're going to talk about today is the going into court and either asking the other side to pay for our attorney's fees, or how to protect ourselves through like liens and whatnot to have our clients eventually pay us for attorney's fees. But before I change gears to talk about that, I did want to allow Vivian at least an opportunity if she had any comments that she wanted to make about the last session that I did with Shelley, because I know she watched it as well.
Yeah, and honestly, I thought it was a great session. And the only thing that I think I would add is that, it's imperative, like the best way to protect your fees with your clients is to constantly communicate about the work that you're doing. I had an opportunity to intern back in the day, over 2 decades ago. Well, 25 years, right? But at the AGC office where the number one reason why people were getting grievances was due to communication. So the more that you are copying your clients on all the work that you're doing and showing them that, in addition to, sending monthly or bi-weekly invoices to them, because I know you guys had a nice discussion about, staying on top of your billings and submitting that to the client. Something that really brings value to the table is communicating and speaking to your client and saying, listen, there's going to be a certain number of hours that I have to put into this. This is what you want to do. Getting written approval from them as well will help to show the reasonableness of your fees. And it will also assist you in attaching that when you're filing a motion or seeking to recover it in court. So constant communication is key, because then the clients aren't so surprised by the bill and they know what's coming. So that's the only thing that I would probably add to that.
Thank you. Yeah, thank you, Vivian.
Thank
So
you.
what we're going to do today, first, we're going to start with some polling questions, and my assistant Jacob is in the background who is going to help me with it so that I don't mess it up, which I've done before. If you have been with me for all of these webinars, you know that I have tried and not necessarily successfully. So we're going to start with some polling questions and have a little conversation about those. And then we're going to move gears into talking about the actual court rules and statutes, and the whole process of getting attorney's fees and going to court to request those fees. So hopefully Jacob is ready to tee up the first question, and then you all in the audience will get to vote. So the first question is, have you ever needed a motion for attorney's fees but decided not to file it because the juice wasn't worth the squeeze? And Vivian and I do not get to vote, so we'll just tell you our answer when we're off. And I'm just going to give it a minute and less than a minute, and then I'm going to end the poll. Okay, not everybody's responding, but that's okay. I'm going to end the poll so we can talk about it. So first I'm going to share the results because I wasn't sure if Vivian, could you see the share?
I can, yes.
Oh, good. Yay. Exciting. Okay, so a majority, I would say a vast majority, super majority said yes, they have decided not to file. So the reason I asked that question today is because I have talked to so many attorneys. I've done attorneys fees presentations around the state. And the one thing I keep hearing from attorneys over and over again is just like, my judge is not going to order attorney's fees. Like, I'm not, why should I spend all this time doing all the steps that are required to prove the request for attorney's fees under the court rules and statutes just to have the judge say no or just give me a de minimis amount. So Vivian, I don't know if you have, thoughts that you wanted to share about that.
I do. There have been plenty of times where I've spoken about it and I've collaborated with the client and, decided against filing a motion for attorney fees or at least warning them, listen, you have the American law in our court system and, the courts tend to be reluctant. A number of them, in my opinion, are reluctant to assess attorney fees against the other party, unless there's a lot of malfeasance by the other party and depending on how reprehensible the other side is. So I think in evaluating, you want to look at, the factors of the case, whether or not, whether you're filing for a motion for sanctions for something that, really harmed and caused prejudice against your case, or was it something like being late, on discovery and, there's a reasonable response from the other side? Is it worth your time and effort to spend there? And what's the realistic goal? And so talking about it with clients and saying, do you want me to expend my efforts here or do you want me to expend it, elsewhere? I think is something that really has to be discussed and a lot of times I would probably click with the 80% that there are plenty of times where I'm like, it's not worth it. I know this judge, they're going to be, a little reluctant to assert these fees. Let's not do it. So it just depends on who your audience is going to be.
So I guess I have a question, and if anybody in the audience wants to drop something in the chat to everyone, my question is, why do you think the judges are I mean, I get the sanction, like if it's really bad conduct, maybe that will push them over the edge, but why are judges so reluctant to award fees? And I ask that knowing that in family law cases, there's a court rule that allows fees based on need. It has nothing to do with misconduct.
Right.
So I'm just curious if you have a thought or if anybody in the audience wants to share if they have a gut reaction. I mean, I have a few thoughts, but
Yeah.
a
I
lot of
mean,
judges already don't like me, so I don't know if I should say.
I don't think it's, oh, I doubt they don't like you, but you're very likable. But I think that I think asserting fees against one party, it comes down to, does this party deserve this kind of sanction? I mean, is what happened worthy of this amount where they're already paying their attorney to represent them, and then they have to now pay this other attorney from the other side? So when it's against the other side, I would say, um, it just depends on their ability to pay. I think would be probably something that they take into account, especially if they find that there were other areas in the case where there was a disparity that's more in favor for your client, especially in family law, right? And then, let's say if I have someone who's the business owner and the breadwinner, and the other side, although they're being disruptive and doing things that they shouldn't be doing and just not abiding by the orders of the court sometimes will be reluctant to really hit them with fees and costs because they can see where the emotion is coming from and that they're behaving from that emotion. So they like to give warnings, but then the court will, there's so many times where I'm not going to award fees today, but if this happens again, file your motion, I'll give you the fees for both, so
I love the warning. I love
yeah,
that because it makes like the clients like, why am I paying for all the work that you're having to do because the other side is doing whatever, and then I
right,
have to pay for all the work that you have to do to ask for attorney's fees just to have the judge say no. But I think the judge telegraphing that, what, I'm keeping my eye on this, and next time I will award fees. It makes the client feel like at least they're getting something out of it, like that it
absolutely,
that maybe the other party will behave better if that's what the issue is.
right.
And that it was not a wasted effort, I guess.
I agree. I agree.
I did want to bring up one example, and it wasn't for attorney's fees, it was for cost.
Okay.
But there was a case where we had an appeal and we retained a remand on a custody matter, and the Court of Appeals retained jurisdiction. And when they retain jurisdiction, they want everything to be done really quickly in the trial court. But
Right.
you also have to supply, and then you have to go back to the Court of Appeals on that same appeal, and you have to supply the transcripts. But the period of time they gave us to do all of that was like 14 days. And so we had to get the
Expedited time.
transcripts, and like it's often not even nowadays. This was pre 2020. Nowadays it's impossible to get them. Like you can't
Mm,
like it doesn't matter how much money you have, you can't get transcripts in a quick amount of time depending on the county. But at the end of the day, when we did our bill of cost and the Court of Appeals gave us a letter saying, hey, these are the taxable costs for the case that we can go into the trial court to get them, I had to do a motion, go in front of the trial judge, and the trial judge was like, well, I feel really bad that he's going to have to pay for these costs because of what I did. I'm like, why should me or my client have to pay because of what you did? It's like,
yeah.
he did
Yeah.
award them. He did give us an
Yeah.
order. And of course, it was an uncollectible order. We never saw the money.
Right.
Like again, and that's the whole juice where the juice is not worth the squeeze. Yeah, like exactly. Because you do
It's
all this work for nothing.
Yeah, and it's that theory of the $1 million judgment against a barroom bouncer. Is the
Hmm.
bouncer going to be able to pay this? So it's really comes down to, is this party really going to have the ability to pay? Or, is it more equitable to split the cost? I'm surprised they didn't require both of you to just split the cost. So that was a huge win for your client to get that, because I tend to see that a lot, is that the courts want the parties to split the cost.
Right, right.
So yeah,
That bouncer may
bouncer
someday
may
win the
someday win
lottery. Yeah.
the
Okay, let's move on to our second polling
hopefully
question.
within
Jacob,
10 years.
number
Yeah.
two. Yeah, renew your judgment.
Yeah.
Polling question number two. And hopefully I'm not doing anything wrong because I don't see it popping up.
You want me to read it?
You can see it? Oh, go
Well,
ahead.
I have the polling questions
Oh, you
too.
have the polling questions that were printed out. I thought
Oh,
it was going to pop up on the screen. There
oh,
it is.
there you go. Okay.
How
Sorry about
often have you obtained the full reimbursement for your attorney fee request? Always, more than 50%, less than 50%, never. And I wonder, we'll talk about to these people in just a minute. Is that enough? I'm gonna give it 10 more seconds. Okay, I'm gonna end the poll and then I'm gonna share the poll. The two people that said always, I wonder if they're very cautious about when they ask for it. So like they only asked, I can't even imagine. I'm like that I just I just never see it, because in all the cases in the trial court where we're reviewing what happened in the trial court, in our own cases where we're going into the trial court to request, for example, appellate attorney's fees, I just never see it. But I bet those two people who said always are probably very cautious in what they present so that they only get what they know they can get. It's
it. And
just a theory.
I'm
I could be
curious.
wrong.
I'm
Yes,
curious the area that they practice in as well.
like
Because
the county, like the part of the
yeah.
state.
Well, that and the area of practice, I mean, is it just family law, or is it, it's civil, or
Right.
because I have to say, for me, it's less than 50%, I would say. Just because of, the nature of the work that we do. And, especially, again, it comes down to ability to pay. And some courts are just reluctant to assess the full amount of the fees, and they feel like, well, your client did hire you and they know how much your fees are going to cost. So, there's that kind of, uh,
Well, yes, exactly. And
yeah,
one thing I wonder
mentality.
is, a judge, even when the judge orders fees, you still have to find a way to get paid them, right?
Yes.
So
Yeah.
I mean, you have to have a judgment if you want to use collection devices. I suppose in the context of a family law case, hypothetically, you could do some sort of motion to compel or show cause because it's in the context of our family law case. But still, like just because you put a number on it doesn't mean that person's ever going to see those fees.
No,
Yeah.
but I will tell you that I did have one with Judge Rashid in Wayne County. This was like 20 years ago when I worked for David Finling, who was a receiver, and I was his associate. And Judge Rashid was so angry that the attorney fees didn't get paid, he appointed a receiver to collect those attorney fees from the other side because they refused.
Wait, he appointed a receiver to collect the fees for the receiver?
No, to
Or
collect
you,
the
or
attorney
Dave,
fees.
or you worked for the receiver who was appointed because of that. Okay, got it.
Yes. So I was the receiver, right?
Yeah,
You know,
yeah.
working for his office. And so the attorney asked for his fees and costs. Judge Rashid ordered this person to pay them. They refused. They consistently refused. He hired a receiver or appointed, should I say, a receiver. And, so there are ways, like, I
That
mean,
is a way. That is not a
yeah,
way that
that
I
is
would
it's
choose.
the extreme way. It's the last resort, and so
Yeah.
you have to be non-compliant to get a receiver involved, obviously, and
Mm-hmm.
on a repetitive basis. But like we said, courts like to give people an opportunity to make things right, and if they can, and if they don't, then you have to collect them in one of those ways. So I think that's why they reduce those amounts a lot of times because
Right.
they don't want you to have to go through it, and they don't want them to have to go through it.
Right. Let's move on to question number 3. That is, while we're letting it boot up, that was a fascinating example. Like,
Yeah.
wow. Okay. Question 3. Do you submit invoices with your initial motion for attorney's fees? Yes, but redacted only. Yes, but not the invoices, just the hours, rates. And no, wait for the court to tell me what they want. And I kind of been all over the board on this. I'm letting people answer, but like I get it's all over the place. The answers are not like definitive, and I understand why. Okay, so I'm gonna close the poll and share it. So, like I said, the answers are pretty evenly split, and I agree. I mean, I would love just to have the court tell me like this is what I want, and then we can go do it. But like, if you don't, you know how it is working with opposing counsel. You don't have everything like tied up with a pretty bow. They're gonna be like, you got to dismiss this because they didn't do all these things.
It's the truth. I mean,
Yeah.
it depends on your opposing counsel. I mean, you could be friendly with them outside of court, but in court, you just know who your opposing counsel is, and that's going to help lead the decision. I think the last three are probably I would click off all of the last three. It just depends on who my opposing counsel is, who my judge is. If I'm asking for attorney fees and costs, and then say to the court asks me, well, how much are you asking for? And I say, well, Your Honor, this is the amount. And if opposing counsel objects, we'd like to have a separate hearing on that, and I can produce copies of the invoices. I bill with specificity with my billings with clients. And so
There's a
sometimes,
lot more to redact if you were to
right.
just submit them, right?
So I think that the one thing that you can do, like when you do have to include your invoices and you have to redact them, make sure those action words and maybe the title, like let's say if you're saying review and revise, motion for, I'm going to say summary disposition just because it's easier, or
Right.
motion for custody or whatever. But, you know, and then you remove the rest, like whatever, especially like if you have a block billing, like I'll do for one file for the day, but I do a breakdown of every single thing I've done. And then I have the point, like let's say point 1 for this telephone call and, like whatever. But
Inside the block billing.
yes, correct. So there's a complete
Oh.
breakdown for my clients so they can see
Mm.
it's not, oh, preparing for a motion. They get to see every integral step that I've, taken and that
That is a great
day.
idea.
Yeah. And so, but inside of that, there might be things like discussions with client regarding, and it's like, no, I'm not going to give that to you. So I'll redact the majority of it.
You keep the word discussions?
Um,
Or
maybe,
like discussions with client and then everything
or
regarding is
tip,
gone?
typically I'll write telephone call with client and
Mm-hmm.
regarding, and so it's like those action verbs, having them in the beginning helps the court to decipher whether or not those are relevant to the award of fees, that if the court has found, let's say for somebody for a motion for contempt, right? And you're asking for attorney fees and costs as a sanction. And the court says, I'm going to give you fees. I just need to know how much. And the other side wants to oppose because they want to see if they're reasonable and appropriate. Well, that's fine, but I'm not going to give you my entire version, because what I've put in there is valuable to my client because they want to remember, oh yeah, you did bill me for that. Yeah, I remember this conversation. It helps them to absorb the fact that, your fees at your hourly rate are adding up. And
Mhm.
so for the court, you want them to only have to see what they need to see, which is what you're working on. But there's also the option to say to the court, I'll provide the redacted versions, but Your Honor, if you want the in-camera review of my billings, I have no problem with that with the court. But we would ask that you review them in camera without the opposing side, having an opportunity to see that because it's privilege, it's confidential, and it's also attorney work product privilege that you can be asserting there. And so some attorneys will disagree with that and say, no, there's case law that says that we're entitled to it. Not if there's specificity and it shows a plan and strategy in there. And the courts can decide on that by an in-camera review. So you want to be careful. I think redacting should always be the way to go if you're going to attach your invoices and then argue it in front of the judge and offer an in-camera review of your invoices to the judge. That's how I don't know. What do you think, Lisa? How do you?
Yeah, no, I agree, and I do redact when I supply it as even if it's an exhibit with my initial motion for attorney's fees. Um, but the whole in-camera, but the funny thing is, so I used to be in Texas and I
Okay.
practiced law in Texas at bigger firms. And there was a lot of in-camera reviews in Texas and with lots of like discovery issues and all that. I haven't noticed it as much in Michigan.
No.
Um, I don't know, like logistically how that would be done. I mean, you hand a document to the judge over the bench and they only get to see it and then they give it back to you so that it's not kept in the file, right? Or
Right.
by Zoom, you somehow do it by Zoom so that they have to delete I don't know, like by Zoom makes it more difficult. But
I think you can
um,
email it to the judge's clerk and then and you just mark it like as confidential and in
yeah.
camera for the judge only, not to be a
Not
part of the
not
file.
not for the file. Yeah, yeah,
Yeah.
exactly.
Yeah.
So, I mean, I think that would be the way to go. Although I haven't really seen judges feeling the need to see what would otherwise be redacted.
I
But to
I
but to
agree.
your point, like I've responded to or worked with trial attorneys in responding to attorneys' fees motions, and I love block billing in our office. We do it. But then when you are on the other side of it and you're trying to defend against having fees against your client, to have a block bill and it's like, 3.5 for the day and there's like six different things and maybe only some of them are relevant to the fee motion because
Right.
maybe if it's a fee motion based on violation of court order, but three of the things you did that day didn't have to do with the violation of court order, just had to do with the regular like processing of the case. It's
Right.
really frustrating to get that block billing because you're like, what the heck am I supposed to do with this? I have no idea how much of this 3.5 is really legitimate to the motion. Your way of doing it is it solves that problem.
Yeah, it really does. And that's why I do it a lot, is because I want to be able to know exactly what I did that day. I want my client to be able to know.
Mm-hmm.
Again, it goes back to that communication piece, where you're letting your client see every little thing that you've done that day. Because if you just write down preparing, like review and preparing for file, for motion, for custody or whatever, and you put in like the 2 hours and you don't break it down, it's difficult for them to understand, right? But when you have or I'm sorry, like you say, 8 hours, right? But this is easier for you too, because then you can redact. Not only are you only redacting those portions that are confidential, but number one, you can see that the verb is up at the beginning of it, and
Mm-hmm.
you're giving the title right away, like telephone with client or review and revise motion for blank.
Mm-hmm.
And you could put in whatever specificity you want after that. You can say review for file and preparation for blank, and you break it down. That way the court can look at that and review it and say, you know what? Now that I'm looking at this 4 hour, motion, but she had to review all these documents. She had to go
Mm-hmm.
through and compare and analyze,
Mm-hmm.
this document to this and do some calculations. She broke it all down. that helps the court to understand that that wasn't too much. And so instead of them saying, no, I'm cutting that in half, they're like, okay, this makes more sense. And it's helpful. And you get to redact only that one slice, that doesn't belong. And then you can manually handwrite in the amount, that you're taking out and reduce that amount on the invoice if you wanted to.
That's great. Okay, one more polling question, and then we'll move on to the court rules and statutes. Polling question number 4. Have you had a case where the other side has brought in an expert for attorney's fees? And I think I'm referring to family law cases because everybody that was invited is a family law attorney, but hypothetically, I guess there could be people that have had other practice areas in their career, like myself. Oh, a few people. Okay. I'm going to end the poll and share it so everybody can see. So very infrequently, I think, in the big scheme of things. I think a lot of times, what do you think, Vivian, that in a family law case, you're asking for your fees to be paid, right? And you as not only an officer of the court, but as somebody who's representing the firm probably can testify about, where the rate comes from and what kind of work you did. We have the economics of law practice. I don't think you need to have an expert witness to testify about the economics of law practice survey. What do you think about having an expert, or when do you think it would be appropriate or helpful to have an expert witness?
I think if you're having an actual full-blown hearing regarding your fees, you might have to have one because sometimes you can't, I got a little distracted from Evelyn's message there, but I'll look at it in a second. Sometimes you can't really be the one to testify as to those fees because you are the attorney that's advocating for your client and for those fees. And so, if you have like a really, adversarial opposing counsel on the other side who's gonna object to the admissibility thereof. Also, I think it lends credibility to have an expert come in. I think in our firm, I think we've only had to do it once, and we ended up settling on that case, so we never really had to use the expert. I just think that it'll help to lend to the credibility and the reasonableness. And when you do have, I think with the State Bar of Michigan's economics of law practice, that's really helpful because it shows not only your years of experience, but like the area where you're practicing, and it shows like where you are in terms of your capabilities. And then you can also then produce your own resume. I mean, I have like certain areas like fraud, for example. I was like an SIU attorney,
SIU?
Oh, so it's Special Investigations Unit attorney. So like I've worked with when parties are hiding assets and stuff, in family law, I can always bring up the fact that I have these skills that maybe other attorneys don't have that lent towards my time, and it helps to, justify the rates, either your rates or your the amount of time that you put in there. But then it's like, can you say that, your experience was lended into this, or is it better to have an expert come in and say that? And so it helps to have that other second party, just lend credibility to it.
Yeah, I hear you. Okay, so that's all we have for the polling questions, and now we wanted to dive into the court rules and statutes that come up in family law cases. So I'm going to try to, there's like 6 that I have written down, and if anybody else has more, please, by all means. But let's just start with just like the sanctions rule, which applies to all kinds of cases. So we have rule MCR 1109E, and also which ties into MCL 600.2591. I'm pulling out my court rules, which I live by and look at all the time. And I use them on paper, although I do look them up online as well, but I just love my paper version that I get every day. So 1109 talks about when you have an obligation to only sign something if you've done reasonable investigation, right? And if you don't do your reasonable investigation, you could be on the hook for sanctions. And it says, so it's a signature requirement. Okay, here it is. It's actually 1109E6, sanctions for violation. If a document is signed in violation of this rule, the court, on the motion of a party or on its own initiative, shall impose the person who signed it, a represented party, or both, so the client or the party, the attorney or the party, an appropriate sanction, which may include, in order to pay to the other party the amount of reasonable expenses incurred because of the filing of the document, including fees. So, it's easiest, I guess, when the court is just doing it sua sponte because they're not happy with what they just observed, right? That's like the easiest one. You don't have to worry about like trying to make a case for it. Vivian, have you filed a motion where you felt the need to request sanctions under 1109?
Oh, yeah, I have. Where the other side is being so unreasonable, and you've even produced, evidence and documentation to support that, hey, there's no need for this. And if you're going to do this, I'm going to ask for sanctions. So I just think that when it comes to this court rule, it just depends, on the circumstances, again, with the courts, did the attorney, if there is an attorney, sometimes people are in pro per in family law, and so, but they're held to the same standard as an attorney. And so, in getting these fees pursuant to this, I think, the number one thing is showing that you made every effort to be reasonable yourself and said, hey, this is frivolous. This isn't, you shouldn't have filed this, or you shouldn't have done this. You could have contacted me first. I'm going to ask that you withdraw your motion, and let's talk about this, or hey, we've got mediation coming up, whatever the circumstances are, to show to the court that you made every attempt to resolve this, and they refused. And so when you're asking for these sanctions, it's like, I shouldn't have to come before this court on something that's so obvious, when, they're just doing this with the intent to harass or embarrass. So that's the thing that you have to remember. It's like, what's the intention behind the motion? Don't you think, Lisa? I mean, what have you
Yeah, and
heard
I
from?
actually, I'm glad you mentioned that because I was like, after having I read E6, I didn't read E5,
Yeah,
which has to do with two different grounds potentially for sanctions, is when you haven't made a reasonable inquiry, right? That
yeah,
the motion or whatever it is you're filing is well grounded in fact and warranted by existing law, or a good faith argument about the extension of existing law. And then the one you just mentioned was the not interposed for any improper purpose, such as to harass or to cause unnecessarily delay or needless increase in the cost of litigation. And so I had to recommend to a colleague recently who was consulting with me that his client got sued. And actually, it was one of my former clients that was sued for something. And we read the complaint, and I talked to my client, my former client, and they clearly did not do any kind of investigation whatsoever because it was
right.
just factually incorrect. And I'm like, see if you can get him to withdraw it, because I think you should go after sanctions. And we had this happen one other time in one of our cases where the attorney was sanctioned and actually was suspended from practicing law because it was like completely. Let me just try to give without giving details. There was an allegation that my clients had done a bunch of bad things and had been convicted in federal court for something. Well, that was actually a relative of my client who had a very similar name, not my
Oh,
client. But they didn't do the like it would have been very obvious if they just did a little bit of investigation to realize before they put in paper in a court pleading trying to advocate for something that my client wasn't the bad guy at all.
right,
And that it was somebody else that happened to be with a similar last name because it was a family member.
right.
Um,
It's different if, like, let's say you're getting calculations, like if there's
right.
an error, or you
Mhm.
think that you think that you've done your due diligence, but your client maybe had provided you um, with the wrong documents, and or the wrong attachment got, attached to the motion, and people file for these motions for sanctions, and it's like, no, I mean, there's
Right.
mistakes that do
Okay.
happen,
Oh my God.
and
And I'm glad you said that.
because we own them and we amend the motion,
Yeah,
you know what I
yeah.
mean?
I mean, we've
But
also dealt with attorneys, and I think you have too, where you do something like sometimes we've had our page numbers on our exhibits were wrong, and not because we are trying to deceive the court. And they're literally asking for sanctions.
Yeah.
I'm like, what are you talking about? Like, what is wrong with you?
You
Like,
know, it's like, why didn't you just call me and ask me to fix it? Or, I agree with you. And
and
so,
the court's not going to grant sanctions for that. Like, I
no,
don't know
they're not.
why.
But even like, I remember I had a case where, my client was providing me with certain documentation, but numbers weren't adding up correctly. So we asserted, a certain number. And then I said to her, listen, this is not adding up correctly, but we're going to file this and then we'll see what their response is. And so when it came in from the other side, it's like, oh, your numbers are wrong, blah, blah, blah. So it's like, okay, we need to dig in, and it requires a lot of in-depth work versus not doing, your research or your work. So it's very different, I think, when you're trying to figure something out and, and the court recognizes that. It's like, but when somebody is just so blatantly refusing, and you've presented all the evidence to them and said, hey, this
Yeah.
is ridiculous, then yeah, you're going to be granted sanctions because you shouldn't have to argue this in court. It should have been resolved between the two of you.
So
The parties are, I'm sorry, I was just
no,
going to say the parties are adversarial. Attorneys don't need to be adversarial. And I say this all the time. And when you're asking for attorney fees and costs, sometimes it's because tempers start to rise a little bit between attorneys. And you have to remember, is that really bringing value to the client or to the case or to their goals? And that's the other part.
great point. So how
Yeah,
do we change that? Because it's among professionals and I keep on seeing it, and I'm not pointing to any specific attorney, but I've noticed since I moved to Michigan 22 years ago, like, and I started doing civil cases first and now I'm doing family law cases, but I don't know that it's that much different. There's just so many times there's a motion filed and everybody asks for attorney's fees. I'm like, what? Like when I was in Texas practicing law, like you did not ask for attorney's fees unless you had a damn good reason, because something was really done that was wrong.
right.
And here in Michigan, it's almost like everybody just has it on their standard form.
It's
And they're,
perfunctory now. Yeah, it's on there.
but it's like, this is a big deal.
But 9 out of 10 times you're not really getting them. So,
Right. So what's then,
so how do we get around that? I think it's
yeah.
trying to resolve things, like on
Mhm.
your own outside of court, I think, and showing the court that you've made that effort. I mean, back in the day on the precipice, I don't know what they're like now with the M file, but because I thank God I don't have to do them myself, but you'd have to like check off that box that said that I attempted to, resolve this with the other side. So before filing that motion, they should be at least sending them to us. But when there is something that's so out there and they're just doing it on purpose to delay, or, then that's something that you do have to go up against, with the court and
Right,
ask for sanctions under 1019.
right. And to your
So
point, only a couple of counties use precipice that I can think of, Oakland
I
and
know.
Washtenaw. None of the
Yeah.
other counties do, but okay, whatever. Okay, let's switch gears. I'm sorry. Switch gears
Okay.
to talk about the family court rules, since
Okay.
that's where we obviously see the most activity on requesting attorney's fees
Right.
because of 3206D. And as you know, there's two segments of 3206D. A has to do with one party is unable to pay or to defend the action, and the
Right.
other party has the ability to pay. And then, of course, this prong two has to do with violations of court order or basically discovery abuses. So we're going to talk about those because I think that's where there's a lot more attorney fees request in Michigan in the family law context because of our court rules and statute as well for divorce cases, uh, envisioning attorney's fees being appropriate in many cases,
Right.
and not for bad conduct either necessarily.
No, and I agree with you. I think, with this court rule, there's this presumption or this myth that, well, isn't he going to pay my attorney fees for a lot of the, well, I'm going to make this less gender specific, but say, aren't they going to pay because they're the breadwinner and I'm the person that's been taking care of the family. And it's like, well, you need to demonstrate the need and you need to demonstrate the ability to pay. And so, and I find it also very interesting when somebody files a motion for attorney fees because they, after the litigation has already started and it's, continuing, but then they're doing this because you're actually litigating and advocating on behalf of your client. And they're like, whoa, like my client can't afford this anymore. And it's like, well, then let's, so it's like, is it then become where there's so much of a disparity? I think it really depends. But for me, I think that it creates a need, for people that actually do have a need, that's one thing, but you have to demonstrate that ability to pay. And I think that's very important. Don't you think that? Or, I mean,
Right,
what's been your
right.
experience with those?
So it's interesting. Yeah. And the question is, at what point do you have to lay all that out? Because putting it in emotion, you can sort of make allegations, but you're going to have an evidentiary hearing about
Yeah,
one party's ability to pay and the other party's inability, right? You can't just have a motion that alleges it. That's not, I don't think is going to cut it.
yeah,
But in divorce cases specifically, there's a statute also at play, MCL 552.13, and that talks about, and I'm going to try to read directly from the language. And one party can be ordered to pay any sums necessary to enable the adverse party to carry on or defend the action during its pendency. I think that's really interesting language in the statute, which only applies to divorce cases, not to just your regular custody case or
right,
post-judgment custody cases. But what I've seen, and I think this is correct, that attorney's fees can be ordered, like you don't have to wait till the end of the case when you have
right,
this giant bill. You can have the other side, if they're able to, right, that they have the ability to pay, have them send over money to the attorney now so that they can, so the other party, that what I'm going to say just for ease of purposes, the non-moneyed spouse has representation, and that attorney knows that they are taken care of through their attorney's fees because they get the money from the other side at the beginning of the case, in the middle of the case, whatever the judge's process is. And it seems to me, you tell me if you have a different experience, but that judges in divorce cases are willing to do that when the statutory requirement has been met, which again, that to pay sums necessary to enable the adverse party to carry on or defend the action during its pendency. Like that means
I
to
have
me
found
during the
that.
litigation. Yeah.
I've also found the courts not willing to do it also because it just depends on the court. And not to get in trouble with any judges or anything, but there are sometimes judges want to see you settle this case and get it off their docket. And so they're like, nope, and so I think that I've seen both in that respect. And what I think happens is, you know, some attorneys will use this as leverage, where if you're going to like continue to litigate an issue, they bring up, let's say, an issue regarding custody, right? And your side is, you know, adamant, this isn't the truth, this isn't, but they have the ability to, like, let's say, schedule for a deposition or something that you need, because if you're going to go to an evidentiary hearing, you need to be able to advocate for your client, you need to be able to do the appropriate discovery that you need to have. And then all of a sudden, if you get hit with this motion, because we cannot continue unless you pay our fees, it puts you in a standpoint where you have to sit back with your client and talk to them about it and say, number one, is it worth it for you to continue this way and pay their fees and our fees? Or is it going to cost you less to resolve this? Is there some kind of middle ground we can find? So I feel like this court rule, in a sense, it's almost kind of brilliantly written by the Michigan Supreme Court, that it kind of almost necessitates, depending on the case, where resolution is going to be, brought together, as a result of it. So you always want to be wary of those that are using it to their advantage versus the people that actually have the need and producing that. So I agree with you. I think it's difficult, I mean, to measure. That's for sure.
Yeah, right. And it's doing the motion's a lot of work. So there's a lot of
Mhm.
different things. One, you have to say, what's the, and you should not just be willy-nilly asking for attorney's fees. You need to help the judges
I
by
agree.
going through this, whatever court rule statute that you happen to be relying on. If it's 3206, articulate how you satisfy the court rule and which court rule you're working under. And if you're working under more than one court rule, then lay it out for both. It's a lot of work. That's the thing. It's a lot of work to do these attorney's fees motions.
Right.
And then you have to not only show that you're entitled to fees or that the court is allowed to award them to you because of what you're citing, like 3206D, but then you have to show that what you're requesting is reasonable, which then, gets into the whole economics of law practice survey and, how many hours and, do we attach the invoices or not? Do we attach redacted invoices? So it gets to be like a really big, drawn out ordeal for the attorney side
Right,
to have to
right,
show it. Yeah.
right. I
And you
agree.
certainly don't want to do all that if the judge is going to say no. So that's kind of like where I like to, if you know who the judge is and kind of have a sense for how they operate, like it'd be nice to have some sort of short preliminary motion, get the vibe from the judge, and then go do the work if they're even going to entertain it. I don't know, like,
Right,
but most judges don't do it like that, I don't think. I think if you either give it to them all up front and then they'll make their decision about whether you should have a hearing or not because it's an evidentiary hearing,
right,
versus like the amount of time it takes to put it all together
right.
without even knowing if they're going to entertain it at all.
I agree. And that's the hard part. It's kind of like a coin toss sometimes. So
Mm-hmm. Now, the rules were amended, and I'm trying to figure out what year it was, but it's been in maybe the past, I'm going to say 5 or 10 years, I can't remember, because now they both A and B both talk about discovery issues. So I
yes,
wanted to point that out, and then there's another court rule that has to do with discovery as well. So I wanted to talk about that for a minute. So 3206D2A talks about they're unable to bear the expense of the action, including the expense of engaging in discovery appropriate for the matter. So if you have a case where maybe one side has a lot of money, but you have to do depositions or do document requests, you should be able to get fees to help you cover all that attorney work that's involved, right?
right,
And then sub B has a provision for the violation of discovery thing. So despite having the ability to comply with the court order, or you engaged in discovery practices in violation of these rules. So
right,
if you're having to file motions to compel because they
right.
didn't respond timely to discovery, that is a place where that's where I definitely would ask for attorney's fees in the
Yeah,
motion. But
yeah,
let me ask you this, Vivian, if you're having to file a motion to show cause or a motion to compel because of something the other side's doing, are you making your attorney fees request just short at the end of that? I mean, tell me how you handle the attorney fee request part of it. Or do you wait till you get your ruling and then bring up the
I
big
I
judge?
like to wait. I like to wait until I get my ruling and then I indicate to the court, you know, what my hourly rate is and if they want to look at the reasonableness of my fees and if the other side wants to challenge it and we say, okay, can we set that for a separate hearing and I'll produce, upon motion for payment. And I've done that before and was successful in one of the northern counties and I collected $26,000 in attorney fees and it was a huge win for my client because but again, you have to remember that the violations and the behavior of the other side was so abhorrent. And so, when you do that, you want to do it where you point out to the court that, look, this is what it cost our client, and you can put in the amount, and then we could ask for a separate hearing so that you can then go through it, depending on, how the other side is going to react because they might be able to work something out with you and your client. You want to give the other side an opportunity to do that as well. And some of the things that I like to do also is to, some attorneys might not like this, but I'll attach the emails of me saying, "Hey, can we resolve this on our own?" And it might not be pursuant to MRE 408. It might be just discussions about, like like if this has been filed, let's say against myself or if I'm filing against them, were there any discussions regarding extensions of time or was there any, issues about when certain, documents were supposed to be presented, that type of nature. And to show the court, like, listen, attempts were made to resolve this. This is what I've incurred. If it's something small, you can just attach it right away. But if it's going to be where it's something big, I would definitely want to have that separate hearing because you want to be able to substantiate your fees. Don't you think?
Yeah, yeah,
Do it that way?
absolutely. Um, and regarding discovery issues, if you are having to bring a motion for attorney's fees because of, violation of discovery rulings, you should also cite MCR 2313B. It's about failing to obey or provide
Yeah.
discovery as ordered by the court. And there's a several point things that you can look at that might help you. It's just more to, I mean, you could get it just under 3206D, but why not bolster your argument and have two court rules where there's one available? Now, we are getting close to running out of time, so I want to make sure we did have a chance to talk with Vivian about the reasonableness of attorney's fees and proving that up. And we'll start, I guess, I think we would start with the Purgu factors.
Yes.
And Lillian, Vivian, I don't know who Lillian
I have
is.
a cousin named
Vivian, 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 I'll let you
Yeah.
start off by, if you want to talk about Purgu and what Purgu is, or
Sure.
yeah.
So it's a Supreme Court case, and it basically modified Smith and Wood, which were two cases that discussed attorney fees and costs. And so they go through MRPC 1.5A factors, which describes and there's about 8 of them, which are the experience, reputation, and ability of the lawyer performing the services, the difficulty of the case, the novelty of the case, and difficulty of the questions involved, the skill requisite to perform the legal service properly, which is why sometimes you'll need an expert for that, the amount in question and the results obtained, the expenses incurred, the nature and length of the professional relationship with the client, the likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer, and then the time limitations imposed by the client or the circumstances, and whether the fee is fixed or contingent. And the court pointed out that these are not exclusive factors. And when applying them, they took a look at whether or not the attorney that presented their fees, if they had presented their case and were able to establish, some of these factors. Now, whether or not they're an exclusive list, I think it depends on the case. I can't remember if
And I think with Purgu, I think what the Supreme Court was trying to do is, like, we had all these different lists in different places, like MRPC 1.5A, we had the Wood factors, we had Smith v. Corey, and they all
Yeah.
had very similar lists, but
There were differences.
slight
Yeah.
differences. And I think what the Supreme Court was trying to do was, at least by case law, which they could do, I suppose, in court rule, was to just come up with one list, I think, to make it simple. A little bit simpler, more simplified. But I have a question about a couple of these, and you may not know the answer, and that's okay.
Okay.
I've always wondered about a couple of these. The nature and length of the professional relationship with the client. How does that impact fee? Does that mean it justifies a higher fee or a lower? Like, sometimes you have people with long-standing clients, and because of that, they have maybe a deal. The client has a deal with them, and they don't pay as much. I mean, I guess I don't know what that's supposed to mean.
Well, so I think that's a good point that you just made. It's whether or not their rate is different versus somebody else's. I mean, is this attorney asking for a certain number that they normally bill everyone else, but they're not billing with this client? That's one point. I think also, in looking at that, the one thing that triggers, like my thought on it is, has this client worked with this attorney for so long, and they know their fees, they know what to expect, and was it so unreasonable, especially if you're going after your own fees against your own client, right? And so, I mean, forget the other side for a minute. If because there's plenty of us that have had to go after and collect our fees. And has this client worked with me long enough to know the quality of my work, the depth of my work, how much time is put into something, and was this something that it was foreseeable to them? Was it, whether or not it was, so if you've been working with a client for years and they already know what you cost and what kind of fees, and about the court process, why are they now objecting to your fees? So I think that plays a part in it.
Okay, that helps. And another one I've often wondered about, and I just had an idea and I wanted to run it by you, whether the fee is fixed or contingent. I'm like, well, of course, most of us in the family law world do hourly, but there could be a flat fee or a cap fee. And I'm wondering if like if somebody has a flat fee, let's just say they agree to do something for $10,000, and then when it's time to submit their bills to get the other side to pay, they have
Yeah.
$20,000 worth of work. I mean, that I guess that should be a factor to consider that you didn't even you made an agreement with your client for something less, but you want us to pay more. I don't know, like
Yeah.
what do you think that is getting at?
Or did the flat fee that you requested, did you do enough work to get
Or
that
the
flat fee?
yeah.
Right? And then the contingency part, I mean, well, you have a lot of personal injury cases out there that when it comes to contingency, and part of these cases were actually against insurance companies because insurance companies didn't want to pay, and they didn't want to pay that attorney fees, because, were those fees, let's say it was $1 million, award to the client and they're supposed to get 30%. Part of that would have been where, did this was this resolved in less than a year? Was there a lot of work? Were there experts needed where you're going to be getting that $300,000 attorney fee award? Did you put in all that time and effort? And I think that's where it comes from, like the cases, like, with the big guns in the state of Michigan. I won't say their names, but I think everybody knows who they are because they're all,
There are billboards.
yeah, they're on billboards and
Just a few.
commercials, and so you know who they are, and so they're getting these fees. It's like, is some of their work perfunctory, or is it some of their work? So they
Mhm.
try to like protect, I think, clients also from that, and for them to justify their fees, because insurance companies were making a big stink about that. And I know that because I worked in that field for a number of years, litigating that very issue, whether or not the attorney even, should have incurred whatever, the no fault law was providing for them. And did
Mhm.
they substantiate or justify it, in terms of their contingency? So, it gets to be on that point. I don't know if it's really applicable to family law as much for that factor, but again, and it says the factors are not exclusive. So
Mhm.
they can consider additional and relevant factors. So, you know, to me, they look at it and they think, okay, well, they're hourly. They can't do contingency. They can't do, we can't fund a client's case, or the other side's case, let's say, and you're waiting for your fees and costs. So the court will look at that and possibly,
Yeah.
take that into account. Does that answer
So
your question? I
yes, it
think,
does. So
yeah,
probably not surprisingly, we didn't get to liens, which I think is a very interesting issue because this topic, which is what happened to Shelley and myself in June, we were very much overly ambitious, and then we decided we needed 2 sessions. And I guess we need 3 sessions because the whole lien issue is really fascinating. And Vivian,
yeah.
having talked to you privately, I think you have a lot of insight to offer on that. So I think we might have to come back and do part 3, which I wasn't planning, but that's fine. We're all good. I just have to sweet talk Vivian into doing it. I don't know if she will. Vivian, thank you so much for
Thank
being here
you.
today. Great insights. We miss Shelley Kester, of course, but I'm
Yeah.
so appreciative that she was able to recruit you to come help out. And you were
Anything for
you were
Shelley.
definitely the right person for the job if she couldn't be here. So
Thank you.
anyway, we look for takeaways. We're going to try to get something out next week. We're going to put all the court rules in. Don't worry, you didn't have to kill your hand taking notes. We're going to get those court rules in there so you can look at it and watch the recording again if you want to. And you guys have a great day. And thanks again, Vivian.
Thank you for having me. I
All
appreciate
right.
it. Thank you,
Bye
Lisa.
bye.